May we start by first spelling out the house rules. Seems that we will need some rules on this platform so that we can conduct our business as smoothly as possible. Before we get there, my name is Donovan Pitt. I will be your instructor for the Magistrates Court Civil Procedure this week, starting this evening and finishing on Friday evening. I'm a practicing advocate for the last 10 years. And before that, I was an attorney for 13 years, 6.5 of which I was a legal advisor in an anti-corruption agency, sorry. Now back to our house rules. Please, I would like to please ask all of you to make sure at all times that your devices are on mute. It is very distracting that during presentation of a topic, and all topics are important, there is someone whose device suddenly unmutes itself miraculously, and we hear songs of a cartoon in the background or a heavy metal song playing. Please let us try to ensure that our devices are muted at all times. That way we will be more productive. I know that we are all facing a challenge with load shedding in the country, so there will be issues with connectivity from time to time. Please try your best to connect via an alternative device or move to an alternative venue where you have access to connectivity. Could we please refrain from marking ourselves present on the chat group? That is also distracting. If all 140 of us have to say we are present, we are not going to get through this night. So thank you to those who have marked yourselves as present on the chat group, but please no more reporting yourselves present. Thank you. Those are unnecessary distractions, colleagues. Let us now focus on the business of why we are here so that we can get through this as painlessly as possible. Right, you were given a program. You were given a program in which is set out what we plan to do for the week. Now, on the first page of that program is written in red, and the red is in capital letters just below the first rectangle with the words Magistrates Court Civil Procedure Program 2023 to 1. Please note all preparation must be done prior to attending lectures. Instructors will not cover areas that are self-explanatory. Please also note sections printed in red below will not be covered by the lecturer at all. Students must do this as self-study prior to attending lectures, please. So there you have the instruction, the first instruction in red. You must please cover as much as you can on your own. The sessions that I will be presenting this week will be as much as possible from a practical point of view. In other words, what happens in practice. I will not be reading from the notes. I will not be teaching you. I may be lecturing you, but I will try to keep it as practical as possible. So please do not ask me which page I am on, or don't ask me which topic I am dealing with. I will be explaining to you as practically as possible as I go along. Now, in your university studies, you were exposed to the theory of the different fields of law. And you had to pass those tests, assignments, and eventually your exams for you to qualify to get your LLB degree. Now the time has come for you to put that theory into practice. You will therefore be called upon from time to time to dig deep into the archives, to try and remember some of the theories that you've learned, because now you need to put them in practice. I know some of us will have to dig deeper than others, but please bear with us. We will try to be patient with each other and to assist each other as much as possible where we can. Now, the aim of civil procedure in the magistrates court is to show you what happens in the magistrates court when civil litigation takes place. What are the procedures that must happen and how are those procedures applied? Now, if you have a pen and paper with you, which you should, I would like you to please write down the following important things. We will be making use extensively of the Magistrates Courts Act number 32 of 1944. The Magistrates Courts Act number 32 of 1944. Now make sure that you get hold of the most recent, the most updated version of that act, because it is updated, it is amended on a regular basis. Make sure you get the most updated version of the act. Now, the second most important document, which I need you to get hold of for purposes of this session, is the rules of the Magistrates Court. And these rules are regulations to the act which I've just described to you. It's rules to the Magistrates Court Act number 32 of 1944. Your rules will basically be your Bible when you deal with the actual drafting in April when we meet again, hopefully. So I want you to, after today's session, get hold of a copy of the Act, the Magistrates Court Act, as well as the Magistrates Court rules. What is civil procedure? You ask yourself. The civil procedure is that procedure that has to be followed by litigants when they institute civil proceedings out of the Magistrates Court. Now, what is the Magistrates Court, you ask yourself? The Magistrates Court is described sometimes as the lowest court of our land. You do have other courts which are seen to be lower than the Magistrates Court, but for purposes of record keeping, the Magistrates Court is the lowest court. And the Magistrates Court is divided into the District Court and the Regional Court. The Act, as well as the rules, apply to both the Regional Court and the District Court. Civil procedure is where, and it's normally compared to criminal procedure. We know in criminal procedure you have the state which prosecutes a person, and that is normally referred to a criminal case. I would not want to normally refer to a person as being a criminal. We refer to a person as a suspect at the time, or the alleged perpetrator until proven guilty. We are all innocent until proven guilty, remember that. But in civil proceedings, you do not have the state, but rather you have a person suing another person. And that person is not necessarily always a natural person. It may be two natural persons suing each other. It may be a juristic person suing a natural person, or vice versa, or a juristic person suing another juristic person. Now we'll explain later on what suing means and instituting legal proceedings against a person. Those two terms are synonymous, and we will be using them interchangeably as time progresses. Now, very important in civil procedure and in all fields of legal practice is something which we refer to as sometimes the holy grail of law, and it's called ethics. Ethics, ethical rules, and professional conduct are always important in all aspects of legal practice. And as we go along, I will be referring to different examples of ethical rules and professional conduct in civil proceedings. Before we even begin with litigation or with civil proceedings themselves, we will have to start at the very basics with the introduction to each other of the attorney and the client. We know that it starts off with a client coming to your office and not necessarily in the street. That's why we refer to professional conduct. You will sometimes, unfortunately, meet clients on the street or at the courts, but it is preferable and advisable that you meet your clients in your office for the first time in a more professional environment. Your client will make contact with your office or with you through your office. And hopefully they will first make contact via telephone. They will call your receptionist. Your receptionist will then require the client to make an appointment to come and see you. But it is advisable that when your client or your potential client calls for the first time, your receptionist or your secretary knows which questions to ask. And it's important for purposes of saving time, because if you do not ask the relevant questions, you may end up wasting your time and the time of your clients, because you will discover that your client or that you do not do the type of work that your client wishes to refer to you, or that your client for some reason does not like you. And some of these issues can be avoided right at the beginning with that first telephone call. And I'll make an example. The client will phone your secretary or your receptionist and ask to make an appointment with you, the attorney. The client will then tell your secretary or receptionist should be trained rather to ask pertinent questions during that telephone conversation. It's important that your secretary or your receptionist is also trained in public relations and how to deal with clients and how to be professional with clients over the phone. A telephone could go along the lines as follows. Good afternoon. This is Hook, Crook and Swindle attorneys. How may I assist you? The client, on the other hand, will say, good afternoon, ma'am. I would like to speak to one of your attorneys, please. The receptionist will ask the client, may I ask what it is about, sir, please? The person will then respond by saying, I need an attorney to represent me in a case. The receptionist should then naturally ask the question, what type of case is it, sir? And may I please have your names? Names are very important because it could be the mother-in-law of the attorney, and he does not want to do, or she does not want to do work for the mother-in-law. So it's important to know who it is, or it could be a politician, and your attorney could probably not want to deal with any politicians or a political party for that matter. So there again, the importance of screening a telephone call beforehand is important. My name is John Smith, and I would like to please speak to an attorney with regards to a summons which I received. A summons? Yes, ma'am, a summons. I would like them to represent me. I am being sued by way of summons by the bank for money which they say I owe them. The receptionist or the secretary then satisfied that the person who is calling is not a person whom cannot be represented by the firm. Secondly, the receptionist is now satisfied that the attorney in the firm deals with civil litigation where banks sue persons. There already, the receptionist will then say to the client or potential client, "Sir, when are you available to attend a consultation? According to my diary, my attorney is available on this day between these times and these times. Alternatively, these are the other dates on which the attorney is available, and these are the times. Please tell me which time will suit you." At that point, the attorney, the receptionist may even say to the client, "My attorney requires a deposit of so much before you consult with him or her. And I would also, after you have paid the deposit into our bank, our trust account, I will send you our email address to which to send the proof of payment, as well as the summons which you've referred to." And the purpose of asking the client to send the summons through before the consultation is so that you as the attorney can go and actually prepare for that consultation by reading through the summons, doing your research ahead of time as to what is the cause of action, which legal principles will apply, and which sources or authorities do you have to consult in order to prepare. That way, you may even sound more intelligent to your client when he or she finally arrives for the consultation, because you will have prepared. Right. Now, when the client does arrive for the consultation, the client will start with your receptionist or your secretary, who will then open what is called a file. It is normally in the form of a manila folder, a huge A3 size, not A3 size, about an A3 size, folded in half, so that the contents, which are normally A4 size pages, are placed inside of the folder. If the client has not paid a deposit at that time, the secretary or the receptionist may require the client to pay a deposit at that time. And when a client makes a deposit or pays any amounts over to the attorney's firm must issue a receipt for all monies received. All monies must be receipted and accounted for properly on the file of the client. Nowadays, we have electronic systems, computer systems, on which the information of the client is recorded. But your normal file administration entails recording on the file cover the names of your client. And these are the full names of your client. Avoid using initials only, because you might find when you are writing a letter to that client, and you refer to that client by his or her initials, only to find that, to your own surprise, in the same household, everyone in that house has the same initials. Now that may create a problem. So it's very important at all times to record the full names of your clients on the file cover. It is also important that you record on your file and you ask for a copy of the identity document of your client. Record the identity number of your client on your file, as well as contact details. Get as many numbers as possible. If the person has a cell phone number or more than one cell phone number, an office number, a home number, ask for an alternative number, a next of kin, in the event that you are not able to get hold of your client for whatever reason. Ask for email addresses, one or more email addresses, where you can communicate with your client. And very important, when you ask your client for an email address and they give you what looks like a work email address, ask them if they are comfortable receiving emails regarding this case to their work email address, because some workplaces do not take kindly to employees using their work email addresses for personal reasons. Remember, these emails are also stored on the company's server, and there they will remain until deleted by the IT department of that company. And where that is the case, where a client gives you a work email address, ask them for an alternative address, personal email, normally a Gmail or a Yahoo email address. I know almost everyone has a Gmail address these days, so it's important that you ask your client for a personal email address, right? Also on your file, you must record your client's employer if necessary, and if the person is employed. Record the employment details on there as well, together with the contact details of the employer, in case you need to get hold of your client for whatever reason. If your client, where he or she works, has a secretary or a PA, ask for the contact details of that secretary or PA in case you need to get hold of your client urgently. And you will need to get hold of your client urgently in civil procedure, because you will be in court to represent your client, and for whatever reason, he or she is not present in court and court is about to start. And if you cannot get hold of them, you cannot get hold of the next of kin, then you call the company or the employer where the person is employed. You phone either the secretary or the PA, who will most likely know where the person, oh, he left his cell phone at home. Oh, he lost his cell phone yesterday. Yes, he is on his way to court. Just wait for him. So excellently, that person will at least be able to get hold of you. And the chances are they will most likely check in with their secretary or the receptionist or their PA at their places of employment to find out if the attorney has not tried to contact them, because they know that number out of their heads and not your number. On the file, importantly, you also need to record the home address of your client, where they reside, in case you need to get hold of them once again and you cannot get hold of them on their phones or cell phones or even at work. Importantly, you need to write on the file what type of matter it is, what type of case it is that you are dealing with. And I'll give you an example. It can be a divorce, which is considered a civil case. It can be a collections matter, where you are collecting a debt on behalf of your client. Yes, your client will not always be the one who is being sued. Sometimes you will be required to sue someone on behalf of your client. Or it can be a civil claim against your client, such as the summons by the bank, that is a civil claim against your client. There are many other examples of civil litigation where civil procedure will apply, and depending on the type of matter that it is, you will then write on the file what type of matter it is to easily identify the file when you need to draw it. And another reason for doing so is because that one client may have more than just the one file with your firm. That client may have 20 cases, and each and every case is different from the previous one. So it's important to be able to identify the file when you do look for it. Also importantly is the referencing of that file. In your firm, you will adopt a referencing system. In other words, each file will be given a reference number in order for you to identify that file. It will also assist your filing clerk when he or she is required to look for that file. And as I said earlier on, your one client may have up to 20 files with you. And it's important for you to be able to identify the specific file that you need to consult at the time of your client or the file coming to your attention. Someone is not muted. Can you please all make sure that your mics are muted? Thank you. Now your client has come in. All the information has been recorded on the file, and the client is now coming through to you to consult with you. You will make your client as comfortable as possible. Offer them something to drink, coffee or tea or juice or water. Do not in any circumstances offer your client alcohol. Do not offer your client alcohol during a consultation. You can think for yourselves why you should not do so. Make your client as comfortable as possible. Remember now, here is someone who is coming to see you with a problem. They are already stressed. They are very anxious. And they are very upset. It is your duty as the attorney to make that person as comfortable and at ease as possible. You must assure your client that you are able to assist them in the best possible way with the possible means available to you in terms of the law. As lawyers, we do not break the law, we follow the law. So you do not assist your client at any time to break the law. Then it becomes an ethical issue, which will, not might, which will get you into trouble. And just a tip on whether when an ethical issue comes up and you are not sure as to whether what you are about to do or what you are doing is the right thing, whenever in doubt, do not do it. It is most probably the wrong thing. But there's also something about this profession that you most probably will not find anywhere else. As colleagues, we are able to call each other and ask each other for advice, which we freely give at all times. So if you're not sure about something, phone a colleague. Phone a colleague. They will most likely be happy to assist you at any time or to give you advice or to point you in the right direction. Now, also, when it comes to ethical issues, the Legal Practice Council is very assisting too, very supportive, especially of practitioners who are starting out. So feel free to, at any time when you're not sure, to call the Legal Practice Council to get an idea from them whether what they are doing or about to do is the right thing or not. They will be very glad to assist you with any advice in the right direction. So it's not all gloom and doom. Big Brother doesn't always have a big stick, so rest assured we are here to help. Make copious notes in your file of everything that happens. The moment when you consult with your client, you write down everything. And as I said, you need to put your client at ease. And in order for you not to miss anything that your client is telling you, get rid of all distractions. Give your cell phone to your secretary, or your PA, and ask them not to put any calls through to you while you are consulting with your client. You want to give your client your full attention. You want to give your client your full attention at all times. And we have cell phones that are distracting. And it is not only rude, but also unprofessional to answer a cell phone call during a consultation, or to answer or read a WhatsApp message or an SMS during a consultation with your client. You want that client to know that they are the most important person in the room. And a practice which I've developed over the years when I consult with the client is that I ask the client if it is in order for me to record digitally the consultation. And I tell my client the reason for that. I do not want to miss anything that you tell me. I'm not a very fast writer. And because of that, I would like to ask you if I can record our consultation so that I do not miss anything. I am yet to have a client refuse that I record the consultation. If you are worried that your client may be more cautious of what they say to you because you are recording the consultation, put them at ease by saying the following when they walk into your boardroom or the office in which they will be consulting with you. I am here to assist you. And in order for me to assist you, I need you to tell me everything and the truth about everything. And I want you to rest assured that whatever you tell me is protected by privilege between the two of us. So whatever you tell me within these four walls will remain within these four walls. I cannot use any of this information without your protection. It is therefore in your best interest for you to tell me the truth, and if you have to say it, the whole truth and nothing but the truth. You will find that that client is very cooperative, and they will tell you everything. They will tell you everything that you need to know. Now, during the consultation itself, it's very important that you let your client tell his or her story themselves. Do not interrupt them. Do not finish their sentences for them, and do not fashion the facts to suit your needs or what you think is the cause of action. Your client must be able to openly speak to you and tell you their story from the beginning to the end. You will only interrupt here and there to ask questions of clarity. When you say you were running or that the other person was running, are you able to tell how fast they were running? Were they sprinting? Were they jogging or almost walking? That's the type of clarity that you seek. But the questions that you ask too must be limited to open-ended questions. Do not ask. The example I just gave you now is an example of leading questions. In other words, do not ask leading questions like, how fast was he running? If he says he was running, how fast was he running? Can you tell me? Don't go as far as saying, was he sprinting? Was he jogging? Was he almost walking? Let the client volunteer that information when you ask the question. Now, very important and this is most probably the most important aspect of your consultation with your first consultation with your client. You must discuss the issue of payment of your fees. You must discuss the aspect of the payment of your fees with your client. This is most often the cause of dispute between attorneys and clients. It's because there's no clear explanation at the beginning. There's no clear understanding by the client, and therefore misunderstanding between the two with regards to payments. Tempers flare, people walk out, and people get reported to the Legal Practice Council, which is unfortunate, but it should not happen. And if you discuss this important issue of fees and payments thereof at the beginning, at the very first consultation, you may avoid conflict at a later stage. And importantly also, once you have agreed on payment of your fees, how much your fees will be, how those fees will be paid, and when those fees will be paid, reduce that agreement to writing. Write it down. Words spoken are often forgotten, especially when it comes to money issues. You must remember, you are selling time. You are not selling anything tangible like apples or bananas. You are selling your precious time. Good evening, sir. You've got beautiful blue skies there. Mr. Mohideen, thank you for showing us the blue skies there. Thank you. Reduce that agreement in writing and write down every single aspect of the agreement between you with regards to pay fees. And at the end of your consultation, have your secretary or your PA type out a fee agreement and let your client sign that fee agreement. Now, once the admin is out of the way, you will then be dealing with the actual consultation itself as to why your client has come to see you. As I said, let your client tell the story. It is their story, not yours. Ask an open-ended question. So tell me why you are here today. Then you sit back and do what is most probably the most important thing that you will ever have to do when you deal with your clients. And that is to listen. To listen. To listen to every single word that comes out of your client's mouth. Because I can tell you from experience that the inclusion or the exclusion of a simple word such as not, N-O-T, can have the opposite meaning of what your client is trying to convey to you. So it's very important that you listen carefully at all times so that you get it right the first time. And remember, if you mess things up because you did not listen to your client can lose his job. Your client can lose his business. Your client can lose his house. Your client can lose his car. Your client can lose his family simply because you did not listen to and follow his instructions properly or at all. So the art of listening becomes more important after I told you that. Even more important than I have emphasized it to be. You need to listen and listen very, very carefully to your client at all times. Many misunderstandings arise because the one party did not listen properly to the other party. And in most cases, it is the attorney. And if you listen properly to your client, you are able to execute their instructions fully and properly. And when that happens, you have a happy client. And a happy client is a paying client. Money may not be the primary objective of why we practice law. It should be the last thing on our minds. But I can assure you that if you apply the principles which I've just told you, and you apply them diligently every time, I can assure you that you will have a client who is happy to pay for your services. But first and foremost, your primary aim and your primary objective is to make sure that your client is happy and that you've executed your mandate properly and fully. Money is the last consideration in this field. I tell you that. If you are here because you want to make money, you are in the wrong place. But if you do execute your mandate properly, money will not become an issue. All right. Good. Now, when you deal with your client during your consultation, you also need to be careful as to how you deal with that client. After your client has given you their version of what it is they want you to know, you have the opportunity to interrogate what it is your client has told you. In other words, I'll use a milder term for it, to test the veracity of what your client has told you. Be as subtle as possible. Do not annoy your client or anger your client with your questioning. Remember, he's still your client or she's still your client, and you need to be sensitive to your client's needs. But make it clear to your client that the reason why you are going to ask these questions is to test the version of your client, because most definitely the opponent of your client will ask those questions. You explain that carefully to your client. It's also referred to as playing the devil's advocate. You ask your client, and where your client does not seem convincing to you. In other words, what they are telling you doesn't seem to be true. Instead of telling your client you are lying, perhaps say to them, I don't think that the magistrate will believe this version. Let's try another version that the magistrate may find more probable than the one you've just told us. That's a more subtle way of telling your client they are lying. They must tell you the truth. But can you see how I've done it in a more subtle way so that your client does not feel intimidated or insulted in any way? Remember, you still have to manage their ego as well. It's difficult work, but it can be done if done properly. At 18:30, I'm going to allow time for questions. And then at 18:45, we are going to take a 30-minute break until 19:15. All right, ma'am, who is showing us the light there? Is it Mpako Chwene? Thank you for those images. Okay, so we'll get to questions at 18:30. Okay. To those who joined late, there's no need for you to report yourselves as present. Thank you. Questions will be answered from 18:30. There's a request. Okay, 30 minutes is too long. Hlakanipo September. Okay. 30 minutes is too long. Okay, I don't think that's going to make any difference, but if that's what you say, then fine, we'll have 15 minutes, but it's not going to make a difference to any of our time, our program for today. Right, shall we move on then?
No, it's not.
I beg your pardon?
30 minutes is fine.
30 minutes is fine. Yes, it is decided that 30 minutes will remain, and it's not going to be
Okay,
debated.
thank you.
It's not going to be debated any further to save time. Thank you. Right, now, as an attorney or a legal practitioner, you may only debit your fees when you've done the actual work. In other words, when your client comes in for the first time and they pay that deposit, they will, let's say, for instance, you give them an estimation of 20,000 rands for the case. And you decide with your client that you will debit fees as and when you do work on the matter. Or you will debit them at the end of each month or the 15th of the month. Now, that 20,000 rand that is supposed to be deposited into your trust account. Now, remember, attorneys are required to open two accounts. One is a trust account into which you put your client's money, not your money, the trust account. And there's a reason why it's called a trust account. The word trust is there. You are entrusted with that money. So at all times, you must be trusted not to put your finger in that pie because it's not your money. And the business account is the second account into which the company's money is paid. So at the end of the month, or when you have performed sufficient work to bill your client for the work done, you will draw up a statement of account or an invoice. Let's make an example. It is 1,300 rands. You will then transfer from your trust account to your business account 1,300 rand as and for your fees. Only after you have done the work, not before, not during, only after. All right. You must apply that rule very strictly and not break that rule it is going to get you into trouble. All right. Avoid charging your client for a matter at the end of the case, right? Because a case could drag on for 2 or 3 years even, and only then will you be payable. But even so, it is a long time for you to have to wait for payment. Remember, you have an office which has overheads, you have rent to pay, you have staff to pay, you have suppliers to pay for photocopiers, for telephone accounts. So you want money to come in on a monthly basis. If you are going to bill every client at the end of the matter after a year, 2 or 3 or 4 years even, you're not going to see money in a long, long time. It's important that you have a running cash flow in your business at all times. It's not advisable to do cases like that. You may do it in some instances, but it is not advisable that you do it that way. Okay. You may do it that way, but it's not advisable for you to do it that way. Remember, if you are earning a certain threshold, above a certain threshold, and it's 1 million rand, you are required to register your company for VAT with SARS, the South African Revenue Service. It's compulsory. It's not optional. It is compulsory. So make sure when you open your firm that you know what those all the requirements are in terms of tax as well as VAT. If you are VAT registered, you're entitled to charge 15% on your fees, but you have to pay that over to SARS. You are now a VAT vendor, meaning that you are actually collecting VAT for SARS, but you're also entitled to a rebate on all items on which you pay VAT. You are entitled to set it off against the VAT which you will be paying. A legal practitioner therefore also has the following duties. Number one, you must be a competent legal practitioner. In other words, you must on a regular basis update your knowledge of the law, especially the areas in which you practice or specialize in. Learning is an ongoing thing. There will be refresher courses offered by the Legal Practice Council, as well as the other associations like Black Lawyers Association, National Democratic Lawyers of South Africa. Make sure you familiarize yourself with those courses when they are offered and attend them on a regular basis to refresh your memory, to refresh your expertise and your skills on a regular basis. Because should it be found that for whatever reason you represented the client with a case in a specific field of law and you did not prepare properly for that case, and as a result your client has now lost their case, you may be held liable. That client may report you to the Legal Practice Council for professional misconduct. So be careful at all times to make sure that your knowledge and your skills, expertise are always updated by going back to read through your notes at all times. Those textbooks that you started buying in your first year at university, you do not throw those books away. We do not throw books away here. We keep them at all times. I still have my very first introduction to law book that I bought in 1990 when I started at university. It is still useful. I still refer to it. I still refer to my copy of Baxter Administrative Law, which is a 1984 copy. It is still relevant. Although there are updated versions of it, I still refer to those books for the basics, and you should do this exact same. Keep your books at all Our books are our tools in this industry, and we do not update our knowledge, we will fall behind. And as I've illustrated, you will get into trouble with the Legal Practice Council. So it is a strict requirement that you are a competent legal practitioner at all times. And on that note, I'm going to sound a warning to you. If you do not know anything about a particular field of law, stay away from it. Stay away from it. It, not may, it will get you into trouble if you profess to have knowledge of a field of law in which you have absolutely no knowledge at all or limited knowledge, and you fail in representing your client fully or properly because of that lack. You may, and you will get into trouble. You will get into serious trouble with the Legal Practice Council because that client will report you. The Legal Practice Council will discipline you. The Legal Practice Council may even interdict you from practice. And we know what follows that. You may be struck off the roll of legal practitioners, and you don't want that to happen. The success that you achieve in this profession is after many years, the longevity of being in practice without any complaints about your professional conduct. That is success in this practice, not the amount of money you'll be making, but how long you can stay in practice, how long you can treat your clients ethically, and how long you can practice as ethically as possible in all circumstances. So towards your colleagues, fellow legal practitioners, you also have a duty to be professional and honest to them at all times. You also owe the court a duty of honesty at all times. If you know about a judgment that is against you, that was recently delivered, you have a duty to disclose that judgment to the court. And should it come to the court's knowledge that you knew about, were aware of that judgment, and you did not bring it to the court's attention, you may be found to have misled the court. That is how sacred the relationship of trust is between the court and you as a legal practitioner. So at all times, make sure that you are not left wanting in that department. You also have a duty to have a thorough knowledge of the substantive and procedural law, which I've just spoken to you about. You also have a duty to constantly be willing to research the law in relation to your client's problems in order to find solutions, if any. You also have a duty to be honest towards your client, as I've just said now, your opponent and the court. And you must never be part of any form of fraud or dishonesty, even if your client asks you to do so. So you will not entertain your client's whims if they are not within the parameters of the law. You also have a duty to act in accordance with your client's instructions. Do not collude with the other side to do your own client in. Your client will know when you've not acted in their best interests. You have a duty to report to your client on a regular basis about their matter. Many legal practitioners have even been struck off the roll for not responding to clients' requests for updates on their matters. I beg your pardon, not struck off the roll, they were disciplined by the Legal Practice Council. So clients who did not get regular updates on their matters reported those attorneys or legal practitioners to the Legal Practice Council for not reporting to them. And when the Legal Practice Council inquired from those attorneys as to why they have not responded to correspondence from their clients, and the Legal Practice Council was not satisfied with those responses, those attorneys were found guilty of professional misconduct, and they were required to pay fines. Yes, they're required to pay fines. So be careful out there. You also have a duty to conduct a relationship of the utmost trust with your client. That is where privilege comes in. Serve your client's interest to the best of your ability. To always honor your client's right to confidentiality. Right. Now we are going to take some questions until our break time. Questions relevant to the topics which we've discussed since 1730, please. If you have a question to ask, put your hand up. I will then indicate that you may speak. Mihlali. Is it Mihlali?
Yes, sir, it's Mihlali.
Yes, Mihlali, what is your question?
My question is, the information says that we are not allowed to take any bribes or be in contact with any fraud. My question is, does getting gifts as a sign of gratitude from the clients also constitute as a bribe?
Can you provide more clarity, please, Mihlali?
Some clients, let's say when we have resolved the matter and the client is happy with the services that you have provided, some clients would want to give you gifts as in like presents, in terms of maybe flowers or chocolates or anything.
Or electricity vouchers?
Yes, anything, sir, just to say thank you, but electricity, no, not electricity vouchers, no, but in terms of something to show appreciation.
All
that
right.
is not money. Yes.
No, I hear you, Mihlali. Thank you for the question. Yes, one would think that normally this applies to government employees, but in our profession too, you will be offered gratuities such as tickets to a rugby game or a soccer game, or gifts, expensive bottles of wine and whiskey and so on. If you are employed by a firm, and if you feel that it is okay for you to accept your client's generosity and happiness at how the outcome of the case was, you may accept those gifts. But if you are employed by a firm of attorneys, make sure that you disclose that to the directors of the firm or the partners of the firm, because they may or may not be happy with you doing that. Firms should also have formal written policies with regards to such issues. And I often find that as lawyers, we deal with these issues when our clients come to complain to us, but we don't implement those things, such as employment policies for our staff, disciplinary policies. It's important that you have policies that deal with declarations of interest. And that is one aspect where you will have to declare a gift when you've received one from a client. And then there will also have to be a gift register where that client has to disclose that gift. And it is then up to the partners or the directors to say it is in order for you to accept it or it is not in order to accept it. But you will be guided by each circumstance in which those gifts are given to you. For instance, and at the beginning I indicated that normally if it's an ethical issue, you will normally have doubt yourself as to whether you should accept it or not. But when you feel that you are not comfortable with the gift, it is in order for you to say to a client, I'm sorry, but I am not comfortable accepting the gift from you. Thank you very much for the gesture, but I would rather that you not that I not accept the gift at this stage. I hope I've answered your question, Mihlali, satisfactorily.
Yes, you did, sir. Thank you.
Thank you for your question. Do we have another question?
Yes, sir. Can I ask a question?
Yes, you may.
On the question of disclosure of judgments, can you just provide an example in terms of that so that we should be able to know what kind of a judgment should be disclosed which have been against you in court?
All right. Okay. Now, we know that our law is based on judicial precedent. In other words, if we are dealing with the case of the National Credit Act, let's say Section 129 of the National Credit Act, and your case is that your client received a the proceeding, the opponent's case is that he did not receive the letter. Your case is that he did receive the letter, and the proof thereof is the registered slip. Now, last week, the Supreme Court of Appeal may have delivered a judgment in which the issue of a Section 129 letter was specifically dealt with in that judgment. Now, we know judgments are published online immediately after they are handed down. If a judgment is handed down today in court, by tonight it should be on SAFLI or the website of that court. Now, it is up to you to know about this judgment. In preparing for your case tomorrow, you will read cases until tonight midnight, or tomorrow morning. You will prepare for that case so that if something that affects your case is decided today or the day before or last week, you should be aware thereof. So that court's judgment, because it is reported and because it is made public, should be in your knowledge. And that reflects on your competence and your ability to research and stay up to date in the preparation of your client's case. And you must disclose that case. If you know about it, you must disclose it to the court. And if you do not know about that judgment, you must be big enough. With due respect, I was not aware of this judgment. But then you must be careful, because now it will go to your competence and your research skills, because you should have been aware of it. Have I answered your question, sir?
Yes, sir. Thank you.
Thank you. Next question.
Advocate, I just want to check or ask this question in relation to advance payment. Well, I heard you saying that we shouldn't, as lawyers, take money before we do or provide service to our clients. But it does happen that you find this client who would say, I have so much money, and this man, I'm afraid that if I don't give it to you, I might use it and be unable to pay for your services. So please do take it and thereafter do the job for me. In such a situation where there's an agreement between myself as an attorney and the client, can that be recorded and be agreed to? Then I take the money. Thank you, Advocate.
Thank you for your question. It is ideal that attorneys, and it is a rule that you are only entitled to the money after you've done the work. Now, remember I said that whatever monies you take from your clients as deposits must be put into your trust account. You cannot put that money into your business account straight away if you have not done the work yet. It's a different story if you've done the work, you send your client an invoice, and your client pays you the money. In that case, you can even tell the client, pay the money directly into my business account, because you're entitled to it. You've done the work and you sent the invoice. Excuse me. But where you have not yet done the work, but you've collected the deposit, that money must go into your trust account. There's no doubt about that. It must go to your trust account, and you can only account for it, or you can only debit that fee for yourself after you have done the work. Have I answered you?
Yeah, that's it. Okay, thank you very much.
Thank you, sir.
Advocate, I just want to ask something.
Yes, you may.
What happened in a situation whereby you are expected to disclose this case that is against your client's case, and it happens that your clients really do want to win this case, and now when you disclose this case, it will drastically affect your client's case and possibly make him or her lose this case? What happens then? How do you manage this situation? I don't know if you understand me correctly.
I do understand you. I'm just trying to figure out the noise in the background. There were people talking. All right. The job that you are required to do, remember, we are in the business of persuading the court in our client's favor. Because a judgment goes against your client, you are obliged to disclose that to the court. You will have to convince the court that that judgment was wrong and that it does not apply to your case. And if you can't do otherwise, if it means that the consequence will be the opposite of what your client wants, then it's unfortunate. It's not your fault. It's the law's fault, because the law is against your client, not you. You must make that clear to your client that in terms of the law, this judgment specifically, you do not have a good case. And therefore, we will not be able to win this case because of this judgment. Are you with me?
Yes.
Yes. I tell you, clients will expect you to do the impossible. Sometimes they think we are magicians. But be big enough to, when your client does not have a case, tell your client you do not have a case. And if that judgment existed before you met your client, you find that judgment, you point it out to your client, explain it to your client in layman's terms, why their case is weak and why it will not succeed. It's ideal that that situation happens before you even pose or defend the case that you are facing, or before you institute proceedings on behalf of your client. But it's your duty to make your client understand from the outset already, before having to go to court to find out that there's a judgment against them, that will stop them from achieving what they want to achieve. The ideal situation is that your client will know before. That is why you do your research before you commence with any action on behalf of your client.
Thank you, Advocate.
Thank you, sir. We have time for one more question.
I have one question.
Take our 30-minute break.
Yeah, maybe just to check. Thank you very much. I'm also keen to understand how we deal with that situation where you become aware of a particular case, because of the cases I have followed, I haven't. I'm not sure. Maybe if people do it privately with their clients, I haven't had any legal practitioner citing a judgment that goes against their case. Rather, they would argue something else to strengthen their case. Like I'd give an example. If we remember the Makwanyane case, which is one of the groundbreaking cases in South Africa, you would remember Makwanyane was given, he was supposed to be killed. And then shortly after that, the interim constitution came into the picture. But then when you look at how the state argued their case, they argued in such a way that killing him would not infringe those rights. They did not argue in such a way that, you know, it was detrimental to their case. So how do we work around that situation?
I don't understand your question yet.
Okay, no, I think what I'm trying to refer to is in regard to disclosing whether a new law or case law that may be detrimental to my client case. My issue is how do we actually deal with that? Because from maybe it's because I have not been exposed to that extent, but from what I have observed is that if they say a new case or law, just like I was giving you in the case of Makwenyan, which said, among others, or rather, the interim constitution, which said, among others, that we need to protect the right to life, which did not exist before the interim constitution. But when you look at how the state argued their case, instead of say they did not necessarily argue as if you know, how do I put it? They even though there was that law, they still argued in such a way that he should be killed and stuff like that. I'm not sure if you're following me.
I'm following you. I am completely following you now.
Yeah.
Now you must remember the state is also the custodian of laws. And where a law has not been repealed yet, they are obliged to argue their case based on the law that is still on the statute books. Now that law had not been repealed, the law that orders the execution of someone for the commission of a specific crime. Now in State versus Makwanyane, the Makwanyane's legal team advanced the constitutional argument of the right to life, which in terms of the interim constitution at the time was to have been deemed a stronger right than the right to be killed. The state had a duty to argue their case in that manner because the law that they were relying on was not repealed at the time. Am I making sense?
Yeah, I'm following.
Are you following? Are you happy with my response? Similarly, so if you have to represent a client and that the law which that client relies upon is not acceptable, but it is still a law. Remember, law remains law until it is repealed or amended. So some of our apartheid laws that applied way back then may still be in force and effect now. Because there's a constitution does not mean that all laws automatically not in line or in congruence with the constitution will be repealed or amended automatically. It is as and when a legal argument comes up specifically. That's why, for that matter, the death sentence may never have been repealed had it not been for the Makwanyane case. It took the Makwanyane case to specifically deal with the death sentence. And it was repealed, the death sentence was repealed or removed because of the Makwanyane case, which argued that the right to life is a stronger life, a right in terms of the Constitution. Am I making sense?
Yeah.
Thank you. You've eaten into 5 minutes of our break already. We are taking our break now. As I said, that was the last question. We're taking our break now. Let's meet back here at 7:15. And we will be pushing ahead full steam until 8:30 tonight. Thank you. Enjoy your break.
Thank you, Advocate.
already. Hello, is there anybody? Hello, is there anybody? Hello, is there anybody?
I am here. I hope I'm anybody.
We are here, sir.
We are back. We are here, sir.
We are back.
Yes, it's not 1:15 yet. Thank you. Okay, we are back from our break now, which you will probably find was more useful than a 15-minute break would have been. Katlejo, it was quiet because we were taking a break. We are back now. Okay, thank you everyone for coming back. We're now going to proceed with what we started before the break. Now, during that first consultation with your client, it's important that you establish a communications tool or a way of communicating. You agree that you will either telephone or you will communicate by email. Avoid using WhatsApp unless you really have to. And the one benefit or advantage of WhatsApp is that you can see when the person has read it. They call it a blue tick. So that may be the one advantage. But because it is a social media tool, I would discourage you from using it. And remember, I said only use it if you have to and if you don't have any other means of communicating. I don't think anyone uses SMS anymore, with WhatsApp having taken over the scene. So make it very clear from the onset how communication is going to be done by both parties, and stick to that. During your consultation with your client, you will also be, is that a hand which I see there?
Yes, sir. Can I ask a question? Sorry I don't mean to disturb your...
You may ask a question, sir.
Is it fine if a disclaimer is put on an email, if it's a company email, so that it absolves you from any hacking or any going to the wrong person?
Yes, it is highly advisable that you always have a disclaimer on your emails. And even if you are a one-man attorney show, please make sure at all times that you consult an IT technician to set up these things for you. We may not all be tech savvy and know how to do these things, but it's advisable to get a technician to do it for you, a professional person in the particular field who's going to set that up for you. Right. Unless you are tech savvy yourself, you may do so. Some of us are limited in some respects, including myself. Right. Now, during your consultation with your client, you will also need to get the evidence that is in your favor, in your client's favor. Your client will be making reference to people who saw or heard something. Those people will be your witnesses in your client's case. Your client will also be referring to documents. Ask your client for those documents, and if he doesn't have or she doesn't have them, ask your client, where are those documents? Where may we get them? There's a process called discovery, where you can get documents, specific documents, when you need them for purposes of trial. Now, when your client mentions to you certain witnesses, ask your client for those witnesses' names. And if your client is willing to speak to those persons to be witnesses, do ask your client to speak to them in an amicable way. Avoid, if you are going to get witnesses to testify in your client's favor, to have to subpoena them, because then you may turn those witnesses into hostile witnesses and they may not want to cooperate with you if you subpoena them to come to court to testify in your client's case. It's advisable to subpoena clients, witnesses who are against you, who refuse to come to court. But as the first port of call, when you ask clients to testify in favor of your client's case, ask your client to speak to them nicely. And if your client's not able to do so, you even try to speak to those clients first before embarking on the subpoena process, the formal process of subpoenaing a client, a witness, sorry. Now, after you've consulted with your client and you've discussed all of these important issues with them, it is highly advisable that you draw up a letter to your client. Now, remember, you will not be able to remember everything by way of memory. So it's important that you write down every single detail about that file in that file and file it meticulously. Make copious notes, file notes, so that you can understand what has happened in the matter. Whenever you need to check on that file, you are able to refresh yourself as to what happened in it the last time and what you are supposed to do next. So make copious notes of everything. You will, at a time, have more than 1,000 files in your cabinet, in your practice at one time. You cannot possibly remember what is happening in each and every single case. So write things down, especially dates, times, people's names, and the contents of those conversations. Write them down and train your secretary or your PA to do exactly the same thing. He or she must ask the relevant questions and write down the relevant information on the file. Right, now we are now going to deal with demand. And you must have heard about the words or the reference to a letter of demand. Now, it is not always legally necessary to request to do a letter of demand. Just a second for me, please. I just have a bit of noise outside my door here that I need to deal with quickly. Sorry about that. Now that I've put them in their place, let's continue. So it's not always a legal requirement that you send a letter of demand to a person, but in my experience, I've found that even where it's not legally required, when you write a letter of demand to someone, they normally comply with your demand. There's no need for you to take any further action. However, there are instances where the law requires you to write a letter of demand. Earlier on, I made mention of Section 129 of the National Credit Act. Now, in terms of Section 129 of the National Credit Act, you are to, before you institute any legal proceedings in a court of law, to firstly issue a Section 129 letter. Now, a Section 129 letter is similar to a letter of demand, but a Section 129 letter tells the debtor what they need to do. There are certain things in terms of the National Credit Act, Section 129 thereof, that you must tell a debtor, the creditor must tell the debtor in that letter what options they have to exercise before you issue summons against them. And if you have not But that only relates to agreements in terms of the National Credit Act, not a loan from a loan shark. Doesn't fall within that. In order for a loan to be a national credit agreement, to fall within a national credit agreement, it must comply with certain requirements. And the Act specifically says what? But the Act also specifically says what must be done before a creditor can sue or issue summons against a debtor. So that is the law. You must follow that. So you must make demand by way of Section 129 and also Section 130 of the National Credit Act. Now, in Section 3 of the Institution of Legal Proceedings of Certain Organs of States Act, number 40 of 2002, any person who wishes to institute legal action against an organ of state in respect of a debt must give that organ of state notice, written notice of his or her or its intention to institute such proceedings in writing within 6 months of the cause of action arising. In other words, if a police vehicle drove into your car and caused damage to your car, and you now want to sue the Minister of Police, because in terms of the State Liability Act, the person you must sue is the Minister of Police. Must sue the Minister of Police as the nominal or the nominal defendant or the political head of the South African Police Services. There are various other functionaries too in terms of the State Liability Act. The MEC for Health in the province. Remember, there's no MEC for police. There's a Minister of Police only, who's the political head. It's only in terms of the national departments like the Minister of Police, Minister of Land, Rural Development and Land Reform, where there's a national minister. There are no MECs. Now, in terms of that act which I've mentioned to you, you have to first of all, before you sue a department, an organ of state, but only in respect of a debt, you must give them notice within 6 months of that happening. So if the police vehicle drove into your vehicle on the 10th of December, 2022, sorry, you have to, before the 20th of May, 2023, send them a written notice of your intention to sue them. So there it's a legal requirement that you must, before you institute proceedings, send out a letter of demand. It's also called a statutory notice in terms of Section 3 of Act 40 of 2002. So it's important that you familiarize yourself with those requirements. Now, one of the reasons for writing a letter of demand to a party is because you want to put that party in default, also referred to as in mora, in default, in mora. Now, you can only complete your cause of action once you've sent the letter of demand and you've placed them in mora. In other words, you have to notify them that they've defaulted, and normally that is based, that emanates from a contract, a written contract, which specifies that you can only be in default if you have been placed in mora. And therefore the cause of action will only be completed once the person has been told that they are in default and they've been given an opportunity to correct the default. Normally within a period of 14 days or 10 days, they are required to fix that. Let's say, for instance, they have failed to pay rent by the 30th. And the contract, the lease agreement says they have to pay they have, after the 30th, they have to be given notice on the 1st that within 14 days, they must correct the default. Should they not correct the default within 14 days, then you have a cause of action. Then you may proceed against them to recover the debt for the outstanding rent. Okay, slight pause. There's a question here. Good evening, sir. Will this be advisable when one charge wasted cost in conveyancing matters as well? For example, one of the parties withdraw from the transaction. John Pinar, are you referring to in mora or letters of demand? Letter of demand. Yes, it's advisable. I always opt for amicable settlement. Litigation is costly, and litigation can take a long time. And in most cases, you find that simply writing a letter of demand, or even just an email to them to remind them, they may have just forgotten to pay you on the date on which they were supposed to pay you, or even they may have not had money on the day that they were supposed to pay. I find that an email, a quick email to them, remind them, you might just strike it lucky and the email might get to you on the day when they just won the lotto or received a big payout, and they'll pay you without having to go through litigation at all. I hope I've covered you, Jean. Michael Buerta, you have a question? Michael, your hand is up.
Evening, sir. I don't know if you can hear me.
I beg your pardon?
So I just want to know if a matter is about to prescribe its outstanding rental amounts, and the matter is actually about to prescribe, would a letter of demand really be necessary, or
No.
could you go straight to serving summons?
Go straight to serving summons, because it's not a legal requirement that you issue a letter of demand. You may issue summons immediately.
Thank you so much.
Unless the tenant is a government department or an organ of state. Then you ask in your summons for condonation of non-compliance thereof.
All right, thank you so much, sir. I appreciate it.
It's a pleasure, sir. All right, can we move on? Any other questions?
Yes, I have one question, yes.
Yes.
Prescribed dates for certain amounts or certain...
I beg your pardon?
Aren't they like prescribed dates in which a response or maybe like a mora, like for the mora, like aren't they
prescribed dates?
Yeah, that have to be followed before like maybe 21.
Your sound is very bad, ma'am.
Yeah.
Hello?
Okay.
Prescribed dates, do you have to put the person in mora? Is that your question?
Aren't they prescribed dates, like days, like maybe for certain types of actions?
I can't hear you.
Aren't they like any prescribed days?
I think it's asking for time limits.
Time limits for prescription?
Yes.
The Prescription Act will tell you, go look at Section 11 of the Prescription Act. But normally a debt prescribes after 3 years of the cause of action arising. And the cause of action arises when it comes to the knowledge of the person all the facts relating to the debt, as well as the identity of the debtor. That is when a debt becomes prescribed. So if the person is illiterate and does not know anything about the law and only becomes aware after 3 years have already expired that they had a claim, you may have a case there for prescription, but normally it's the date, on the date from when the cause of action occurred, 3 years after that, then a claim is deemed to prescribe. But each case is looked at on its own merits, depending on the circumstances and the facts. Have I answered you?
Yes.
Thank you. Yes, next question. Let us, before the next question, let us try to keep it relevant, please, with regards to the topics that we are dealing with. All right?
Also, I would like to ask a question. Is there a condemnation in filing the statutory notice?
Yes, there is a condemnation.
There is a condemnation.
You may apply for condemnation, yes.
I see.
All right. But the claim must not have prescribed, number one. And then secondly, there must be a good explanation for the delay as to why there was the condemnation was not done within the prescribed time. The notice.
Thank you.
Thank you. All right. We've digressed a bit. If you have made demand where it's not necessary, where you've written a letter of demand where it's not necessary in terms of the law, and then the defendant then, after receiving summons, offers to pay the debt within a reasonable time, you, the plaintiff, are entitled to the costs of that summons if you have issued a letter of demand where it is not necessary. All right? Don't worry too much about that. Now, if demand has not been made, if it's not necessary for you to demand payment from the debtor before you issue summons, the debtor cannot use that as a defense for their claim. All right, they cannot use it as a defense, either as a denial or as a special plea, or even an exception. We'll learn more about that as we go along. So if it's not required of you to put in your to make demand, to write a letter, send a letter of demand to the debtor, you need not even in your summons or your particulars of claim make the allegation that you have made demand and that there was no compliance with that demand. A demand may be either formal or even oral. In the case of where it is required to be done in terms of the law, it obviously must be done in writing. That's the only way you'll be able to prove it. Can a student loan NSFAS prescribe? Yes, it can. 3 years. If a plaintiff, your client, has demanded payment from a debtor before seeing you as the attorney and can prove it in writing, of course, then there's no need for you to do further demand as the attorney. Your client's demand may be used if it is a requirement that demand be made before summons is issued. So there must be specific demand made for payment of the debt. If you render an account to your client, if your client renders an account to their debtor, it's not tantamount to a demand, right? And by the way, your letter of demand does not have to be in fancy language, as long as the message is clear. If your client writes a letter, and this applies to you too as legal practitioners, try to use plain, simple language. Remember, you are writing for a person who is not a lay person. Now, some legal practitioners prefer to use high and fancy and mighty words that so often become diluted and not understood by the lay person who's receiving. Please be advised that our instructions are to demand from you, as we hereby do, payment of the amount of 185,000 rand within 10 days of this letter, failing which summons will be issued against you, or legal proceedings will be instituted against you. That itself was a mouthful. Keep it simple and short. Pay me my 185,000 rands immediately, full stop. Short, sweet, and to the point. You don't need to use big bombastic words. Pay my clients 185,000 rand immediately into this bank account, full stop. What more can they ask? They can't ask for explanations of meanings of words. It's clear, it's crystal clear. Right. We've dealt with claims against organs of state. We've dealt with the legal proceedings against certain organs of state. Now, we are going to look at the Legal Proceedings Against Certain Organs of State Act. That act is actually called the Institution of Legal Proceedings Against Certain Organs of States Act, number 40 of 2002. Now, that's an important piece of legislation, which you must always have with you, and make sure that you keep an updated version of that act, because since its inception in 2002, it has been amended somewhat. There are certain things that have changed about it. So when you download it from wherever, make sure you get the most updated version. So the act, when I refer to the act now, I'm still talking about the Legal Proceedings Against Certain Organs of State Act. That act, in terms of that act, in order for you to invoke the provisions of that act, the claim that you are dealing with must be classified as a debt. And what is a debt? Debt is money which you owe to someone. But can you say a claim for medical negligence for 25 million rand against the MEC for Health is a debt? You haven't proven that you're entitled to it yet. Can you say it's a debt? Yes, it is a debt. Because should they be found liable, it will be considered to be a debt, especially if they can't pay you. And we all know that these medical negligence cases amount to huge amounts of quantum, and therefore, and in some cases, the departments are unable to pay them. More particularly the Department of Health, which I referred to, because of their budgetary constraints, they don't have that kind of money. But much more on that later on. So a claim then becomes a debt. A debt is not always liquidated. A debt may be unliquidated as well. And when I say liquidated, I mean a specific amount. Although you are claiming 25 million rand from the Department of Health for a medical negligence case, does not mean you are going to be awarded that 25 million rand. The court may find that your claim is only worth 15 million rand or 1.5 million rand. That nevertheless still makes it a debt, as opposed to a liquidated amount. And an example of a liquidated amount is, let's use the same Department of Health. You are a service provider who sells medicines to the Department of Health, and they order medicines from you. You send them an invoice for 28 million rands for those medicines. Now that is a liquidated amount because it is not in dispute. You've provided medication for that to the value of 28 million rand. It is not in dispute. It cannot be disputed. In other words, it is a liquidated amount. That is what a liquidated amount is referred to, or a liquid amount. Okay, and the invoice that is issued in respect of that 28 million rand for that medication to the Department of Health is referred to as a liquid document. So you can use that liquid document to obtain what is called summary judgment. We will deal with that at a later stage. Or you can even use it in a it's a summons. It'll come to me later on. I just forget now. Just bear with me for a moment. Provisional sentence, I beg your pardon, that's the word. Provisional sentence summons. You may use that invoice as a liquid document in support of a claim or in a provisional sentence summons. Right, now so coming to the issue of a debt again now. The debt must arise in order for it to fall within the Act 40 of 2002. It must arise from a contract or a delict or any other liability. I've made two examples for you now. One in terms of the contract, where the medication was delivered for 28 million, and a delict. A delict is a civil wrong or a tort, T-O-R-T. In this case, the claim for medical negligence against the MEC for Health is a delict, right? Or any other liability or a debt, in other words. It must render the organ of state liable for damages, right? And then again, an organ of state can be the following: any national or provincial department, a municipality, any functionary or institution exercising a power or performing a function under the institution or a provincial constitution. The constitution or a provincial constitution. So it's the National Constitution, Act 108, or a provincial constitution. The South African Maritime Safety Authority is also an organ of state in terms of the Act. The South African National Roads Agency Limited, SANRAL, they are also an organ of state. And any other person for whose debt an organ of state is liable. So it can be an employee of a department. If that department is liable for the debt of that person is also deemed an organ of state. Right. So we've spoken of the notice. Now the notice must be given in writing, as we said, within 6 months, and it must be delivered to the relevant official. It must comply with all the requirements which are set out in section 3, subsection 2. And section 3, subsection 2 states that you must, in your notice or your letter of demand, state the facts upon which your client relies for the debt. It's provisional summons, not provincial. So you must state the full facts upon which your client relies for the claim against the organ of state. You must state how the incident took place. Full facts, in other words. In order for the organ of state to be able to investigate the facts relied upon by your client. So there's a reason why the law has said that, or says that, you must give the organ of state statutory notice so they can investigate the circumstances. Excuse me. And that is fair because it may not even be necessary for you to issue summons against them subsequent to that letter, to that notice, especially lately, because the organs of state or the government departments are now trying to curb litigation against departments by putting in place early interventions when the statutory notice or the letter of demand in terms of section 3 is received by that department. They are now required to act speedily to investigate the circumstances of that claim. And should they find that there are grounds upon which the plaintiff or your client may have a claim against them, they will very quickly try to enter into negotiations with you and try to settle the matter before it even goes to court. Because the moment you institute legal proceedings by way of summons or otherwise, it becomes a public matter. That is why you see every day in the newspapers, there are reports on cases that are in court. It's not by coincidence. It's not because somebody at court phones a journalist and says, there's a juicy story here. No. Journalists visit courts every day. And because your case is now it's public document. Your pleadings become public documents. Any member of the public is entitled to them. So journalists go to the registrar's office or the clerk of the court's office, and they ask to see their roll of new cases. And they are given the files and they can go through the files. And if they find that any of those cases, those case files contain a juicy story, they will publish it. Journalists are trained to read pleadings and to be able to discern from those pleadings what the case is about. So yes, coming to condonation now. When you are now going onto the stage of issuing summons, right? In terms of your delict, you have to make the allegation in your summons particulars of claim that you have complied with the provisions of section 3 of the Act. And you may even go as far as saying that the statutory notice was sent to the defendant, the organ of state, on this date, and here is a copy attached as proof thereof. You will find that you don't have problems if it was sent within the 6-month period. If it was not sent within the 6-month period, this is now in respect to the organ of state, or if it was not sent at all, the defendant, which is the organ of state, represented by the state attorney's office in this case, will file what is called a special plea. And in their special plea, they will specifically state that the defendant is an organ of state. Therefore, the plaintiff was required to send a statutory notice in terms of Section 3 of Act 40 of 2002 to notify the defendant of its intention to institute these proceedings. The plaintiff has failed to issue the statutory notice. And because the plaintiff has failed to issue the statutory notice, their claim is incomplete. And therefore, the claim must be dismissed with costs. In that case, then, will the plaintiff be required to bring an application for condonation of the late filing or the non-filing of the statutory notice? Would this be the same for the NCA 129 notice? I don't understand that question. Referring to what? Kaganipo, September. Can you please elaborate on your question? Would what be the same for the NCA? What about the letter of demand? Yes, sir, it is compulsory. Sir or ma'am, I'm not sure. Yes, it is compulsory for letter for the Section 129 notice to be sent. Without that, your cause of action is incomplete if you are relying on a national credit agreement. Okay, if your cause of action is based on a credit agreement, it has to comply with Section 129 in that the notice must be sent. Now, when you apply for condonation, I hope I've answered you. When you apply for condonation of not complying with Section 3, then you have to bring an application now on notice of motion. We'll deal with that later on. In your notice of motion, you must state that the debt is not prescribed. In other words, it's still within the three-year period. You must also state that there is good cause for your failure to not send the notice at all or not send the notice within 6 months. And lastly, you must say that the organ of state which is affected here was not unreasonably prejudiced by the failure of the plaintiff to either not send the notice or to not send the notice within time. Those three allegations are very important. If you don't make them in your affidavit supporting your application for condonation, you may not be entitled to condonation, depending on the judge before you. Okay, right. Now, how the notice must be sent. It's important that you familiarize yourself with how the notice must be served on that organ of state. The Act specifically tells you, Section 4 tells you, you may only send the notice to this organ of state by 1, delivering it by hand, or by sending it by certified mail, or by email, or by transmitting it by fax. I don't think anyone uses a fax anymore, just like a checkbook. But electronic mail is email. But then in addition to that, you must also prove that you've sent it to the correct email address. And you'll find that with organs of state, they normally have designated email addresses on their website that deal with specific issues. If your claim has prescribed SIPO, you will not be granted condonation. You may as well not even apply for condonation if your claim is prescribed. Because in your application for condonation, if you do not deal with prescription, or you say in your application, you must remember now, an affidavit is under oath. And if you say under oath that your claim is not prescribed, whereas it has prescribed, then you are guilty of a serious offense of perjury. So you better be careful. You must know your facts when you apply. So if you find that your client's claim is prescribed, it's not even worth applying for condonation, because then you'll be opening yourself up to various other issues which you don't want to invite. Obakeng, your hand is up.
Yes, can I ask regards to in the case where the organist raised with regards to non-compliance with the notice. Does the court have jurisdiction to grant condonation without the plaintiff having made the application for condonation?
No, the Act specifically states that application must be applied for.
So the failure of the plaintiff to make such an application, like, it kills their case completely.
In the absence of an application, yes.
Yes.
But the plaintiff may also request the organ of state to consent to condonation, thereby circumventing the need for an application for condonation.
All right. So the matter will go on trial, and the court will hear a special plea, and then that's the end of it. We don't need to move the plea merits.
Yeah, the plea on merits will not be dealt with until the special plea of condonation has been dealt with.
All right, thank you.
Thank you.
One more question. There are 10 periods, right, in which that application must be brought?
It's within a reasonable time, a reasonable period of time. But the sooner you bring it, the better, because then you have to explain less time for not having complied. The longer you wait for it, the more problems you experience in terms of time frames, because now you are not showing the court that you brought the application for condonation as soon as you were able to bring it.
All right, and that would be before the matter goes on trial, I suppose.
Definitely.
All right, thank you.
Thank you. All right, Wade has a question. Is prescription of a claim halted? When a letter of demand is issued. Okay, let's see what Mabato Klapi has said. Only summons as far as I know. Okay, Mabato. A letter of demand does not interrupt prescription. All right. Letter of demand is not a valid document for purposes of pleadings. Only a summons will interrupt prescription. All right. Mabato, you were correct. Wade, I hope you understood. Is there another question? Alphas?
Okay. Well, you indicated about the issue of the state trying to minimize the issues of litigation. I think it's for the mere fact that they are losing cases, and that is why maybe they have huge budgets that they have to use to, to pay some of these legal challenges that they get. Now, I just want to check something. I'm not so sure whether I'm jumping the gun here with regard to the issue of mediation. If mediation is being made compulsory, or is it still at a stage where it is actually proposed, or people may choose not to take it or to take it?
Okay,
Thanks,
yes,
Chair.
you are completely jumping the gun. You are completely jumping the gun. It is still something that I'm going to deal with at a later stage. But
Okay.
yeah,
It's
let's
fine.
rather deal with it when we get to it, okay?
Okay, sure, thanks.
All right, thank you. So, and the service of process now on a legal, on an organ of state may only be done, served on the Minister for State Security also. In other words, the DG, the Director General of State Security Agency. If it's on the Minister of Police, it must go to the National Police Commissioner. If it's for the Provincial Commissioner of the South African Police Service as well. Also to the Minister of Correctional Service via the Commissioner of Correctional Services. And lastly, the Provincial Commissioner of Correctional Services himself. Okay, or herself. We've touched on the National Credit Act as well. We've dealt with it. We are now going to start on the issue of jurisdiction. Right, now you may have come across this word a number of times. Alphas, can I ask you to put your hand down, please? Otherwise, you'll be very tired at the end of the session. Thank you. Right, now coming to the issue of jurisdiction. This may be a word that you've heard of a number of times in the movies or the TV programs that you've watched. What is jurisdiction? Now, jurisdiction is the competence or the power of a court to hear and determine an issue between parties. In other words, can the court hear this case? Yes or no? And the issue of jurisdiction is very important. And there are different jurisdictional points which inform a party whether a court can hear a case or not. And there are various principles which we will be dealing with on which the issue of jurisdiction is based. We'll get to that in a moment or in time to come. Now, magistrates' courts are considered creatures of statute or legislation or acts of parliament. And magistrates are said not to possess a discretion. So they have to act within the confines of the Magistrates Courts Act, number 32 of 1944. They cannot venture beyond that unless they are developing the common law, which I don't think is capable of being much developed in terms of magistrates' courts actions. Now, the first aspect of jurisdiction that is looked at is the court itself. Whether the cause of action falls within that particular court. I'll make an example. I will take the jurisdictional area or geographical area of King Williamstown, or Corne as it is known now. King Williamstown is 4.5 kilometers from Bishop. So there are two magisterial districts right next to each other. If a motor vehicle accident happened in Bishop, 4.5 kilometers away, the plaintiff cannot go to the King Williamstown Magistrates Court to institute legal proceedings against the defendant. Immediately, King Williamstown is excluded from the jurisdiction because of the area in which the accident occurred. Now, let's say the same motor vehicle accident, right? These are rather expensive cars that were involved in this accident. Now, the plaintiff who wants to sue the defendant in the Bisho Magistrates Court, or rather it will be the Zwelicha Magistrate, but let's say Bisho because I don't want to confuse you. The Bisho Magistrates Court is divided into a district court and a regional court. Now, the regional court, the district court has a jurisdictional monetary limit of 200,000 rands. So anything above 200,000 rands, or rather anything below 200,000 rands, falls within the jurisdiction of the Bisho District Magistrates Court. Anything above 200,000 rands falls within the Bisho Regional Magistrates Court, because the monetary jurisdictional limit of the regional court is 201,000 rands up to a maximum of 400,000 rands. Anything above 400,000 rands does not fall within the jurisdiction of the Regional Magistrates Court or the District Magistrates Court. Now, in the accident which took place in Bisho, the defendant resides in King Williamstown. Although the accident happened in Bisho, the defendant resides in King Williamstown. Now, both the Bisho and King Williamstown courts have jurisdiction to hear that matter because, number one, the accident, the cause of action, happened within the jurisdictional area of Bisho. The second court that may have jurisdiction is the King Williamstown court because the defendant resides in King Williamstown. So the rule is the plaintiff must follow the defendant, or in applications, the applicant must follow the respondent to where they reside, are employed, or carry on business. That's enough. So you see, there are a number of factors to take into account when you want to decide on which court has jurisdiction. It's important that you do know which court has jurisdiction and for what reason. And you must, in your particulars of claim, when you are drafting your summons, and I'll explain later on what particulars of claim are, that the reason you are saying the court has jurisdiction is because, number one, the cause of action occurred within the geographical area of the magistrates of the court. You may also say the court has jurisdiction because the defendant resides within the area of the court. You may also say the court has jurisdiction because the monetary limit falls within the jurisdiction of the court. And you have to state specifically why. And it's important. We will deal with drafting next in April, where you will see that it's important that you make those allegations when you are drafting your particulars of claim. Okay. Right. Now, the National Credit Act, you will see, comes up a number of times. Yes, Mr. Eric Mukari, your hand is up.
Thank you, Advocate. for giving me the time. I just heard you saying that the defendant, you need to go where the defendant is. Does that apply to the divorce jurisdiction? Is it still the same principle?
No, it's not the same principle. In divorce proceedings, you, the plaintiff, have the choice as to either where the plaintiff is or where the defendant is.
Oh, okay.
Yes.
Then what about the course of action? Say, for instance, we are married in Pretoria. Then I want to, the plaintiff want to proceed with the divorce, currently staying in Devon, and the defendant is in Cape Town. What will be the jurisdiction, court of jurisdiction?
Durban or
in
Cape
those
Town.
areas?
Durban or Cape Town, not Pretoria.
Sorry?
Durban or Cape Town have jurisdiction, not Pretoria. It's the parties. They don't look at the cause of action.
Okay.
We're not talking about a car accident here. Remember now, the cause of action is the divorce, not the marriage.
Oh, okay.
Yeah. So they look at where the parties are based. If it's Cape Town, if it's Durban, they don't look at where the marriage took place.
Oh, okay.
But you only have to establish that one of the parties is domiciled within that area of jurisdiction of the court where you want to institute the proceedings.
Okay.
Thank you. Okay, was there another hand up?
Yes.
Putitao.
Yes. No, I wanted to check if the defendant maybe is a big company station, the headquarters is in Cape Town, and you are here maybe in Limpopo. The course of action happened here. What will happen? Because the headquarters are in Cape Town.
I would say, to be safe, rather go to Cape Town. But you may use the cause of where the cause of action arose as your jurisdiction. You must remember the issue of convenience is also at stake here. So you may say the cause of action is here, but remember another basic principle of jurisdiction is you have to follow the defendant where the defendant is. So if the defendant's head office is in Cape Town, it will be advisable to issue to institute proceedings out of Cape Town. Are you satisfied with my answer, Mr. Lyon?
Yes, I am.
Thank you. Mr. Naidu?
Advocate, in terms of a property, if a property, for example, if it was sold in, or there was an old agreement in Cape Town, but it was signed electronically, say in Gauteng, and there is a dispute pertaining to the OTP, which court has jurisdiction?
So it was drawn up in Cape Town?
Yes.
Signed electronically in Gauteng?
That's correct.
By whom?
It was signed by the seller.
Signed by the seller in Gauteng.
And the buyer also resides in Gauteng, but the property is in Cape Town.
Cape Town, sir, will be your jurisdiction, because you must look at also whether the court will be able to enforce that order or any judgment resulting from litigation. Gauteng will not be able to enforce, the Gauteng courts will not be able to enforce a court order or a judgment in respect of a property which is not within Gauteng. Yes. So it'll be advisable to institute proceedings in Cape Town in that regard.
Thank you.
Where the property is situated.
Thank you, sir.
Thank you.
Advocate, just to check here, what is the rationale for following a defendant in terms of making these claims and not the applicant?
It's the rules, sir. It's in terms of the rules.
Okay.
Okay.
So if the court wants to attach something, imagine
Mr. Tao, your hand is up. I also hear whispering in the background. Who is talking? Am I? Isaac. Yes. Attachment is key. Mr. Sipo Simon CB, yes, attachment is key. You are quite right. You're able to attach the property and then you use that. You can use that as your course of action. Dlamini.
Relates to contractual conditions and not the itself. Taking the example of the property in Cape Town and the signage in Gauteng, what court will then have jurisdiction?
I beg your pardon?
Okay. If issuing the elements of the contract and not the property necessarily itself, or
if the contract states that another place has jurisdiction other than where the property is situated, is that what you're referring to?
Yeah, quite possibly. See, the property is in Cape Town, but if the issue at hand is some legal term within the contract itself and not specifically relating to the property necessarily, what court will then have jurisdiction?
Where the breach has taken place.
Okay, thank you.
Yeah, or the party may then follow, then you may follow the defendant in that case. You won't be lost if you follow the defendant, if it doesn't have to do with the property itself directly. But it's always safe to institute proceedings where the property is situated.
If I understand that question correctly, I think he was trying to say, what if the parties decide in the contract itself that the jurisdiction will be in a specific court?
Yes, but that could also be wrong, which means that there could be something wrong with your contract if it has to do with the property itself. So that's why it's important that whoever draws up the contract makes sure that the terms and conditions of the contract are competent and able of being executed legally in terms of the law. Because you may say that all disputes with regards to this property will be resolved in the Johannesburg courts, only to find that the property is situated in Cape Town, which means that your contract is incompetent in terms of that. Do you hear me?
That's correct.
So it's important that you draw up a contract that is legally competent. Otherwise, that contract will be set aside and the parties may rely on the common law to litigate. That's why I always say, if the first port of call is where the defendant is, and where, that's why you have to know the law, where you find that it has to do with the property itself, logic will dictate, or the law will point you in the direction of where the property is situated. Am I clear?
Advocate?
Yes.
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 Two questions. One is, if there is a breach in the contract.
Yes.
and you're contesting the breach on the OTP. Now, I think you earlier indicated that you have to follow the defendant.
Yes.
So that case must be heard. Yeah, and if the defendant resides, for example, in Gauteng, that
Right.
case Gauteng court. Am I right?
Right.
Second question is, in terms of signature, in terms
Yes.
of the electronic act,
Right.
the only time you can, or there's only one instance where you cannot sign electronically is where it involves property. When it involves property in terms of the Electronic Act, you got to sign with delible ink. You cannot sign it electronically.
Right.
Am I right in saying that?
You're right in terms of that, but you must also go back now to the law of contracts as to where a contract is concluded. Remember, a contract is an offer and an acceptance, and a contract is concluded when the offer is accepted, right, by the party. So if it's done electronically or it is done digitally, or the party accepting the offer, where that party is based will be determined where that contract is concluded, because when it reaches the knowledge or the ears or the eyes of the person making the offer, accepting the offer, I apologize, that is where the contract will be concluded. It's the same with telephonic contracts. These insurance contracts that you take out over the phone, you as the insured accept the offer of insurance. Remember, contract is also insurance is also a contract. You accept the offer telephonically. It then reaches the ears of the consultant, the telephonic consultant who represents the insurance company in Johannesburg at their call center. Johannesburg will be the place where the contract was concluded. That's the basic principle. Now,
Yes.
coming to jurisdiction, in the magistrate's court, you can consent to jurisdiction, but it's tricky. I think it's section 45 of the Magistrates Court Act says only the defendant can consent to jurisdiction of an amount more than the jurisdiction of a magistrate's court. Only the defendant, not the plaintiff, the defendant can consent, not the plaintiff. Petri, I hope I've answered you. But go and have a look at section 45 and section 46 of the Magistrates Court Act as well, just to satisfy yourself.
Advocate, if I have to sue someone from another country, which law will apply?
Mr. Matebula, you are taking us out of the jurisdiction of our subject today.
Okay.
Yeah. Tomorrow we will be dealing with that. Okay. Please remind me. But for purposes of today's session, that is where we are going to stop today. I will allow one more question before we bid ourselves farewell for the day. One more question. Going. Gone. All right, let me then take the opportunity to thank you for your time and your participation this evening. It was indeed fruitful. I hope you found it the same way. Tomorrow we will continue with jurisdiction. We will also be dealing with jurisdiction is quite long. It's quite a lot. We still have to get through. We've basically just touched on it. But tomorrow we'll get to a bit more in depth. And then we'll also be dealing with summons, the different forms of proceedings, action proceedings. Yeah, so please, if you can, read ahead. And I'd like to also ask you, when it comes to questions dealing with aspects which I have not touched on yet, give me just a little bit of time before we get there. I promise you they are there. And normally the questions that you ask, I will still be dealing with in the next session or so. But any questions are welcome, but let's try to keep it relevant so that we don't waste time on stuff that is not relevant. Thank you very much. Enjoy your evening and have a good day tomorrow. See you.
Thank you.
Thank you.
Thank you, bro.
Thank
you.
you, advocates. Have a good day.